With regard to indemnity and yesterday indemnity and guarantee we have done. So any questions you have? Have you gone through the Bare Act? Okay, today I want to know that whether you want to study from the PPT or you want to do it from the Bare Act itself. Like I don't want to do according to me right today. I want you to give me an opinion whether you want to study it from the Bare Act directly, then we can directly go through each and every sections and then discuss, or we can the way we are doing it earlier, similarly we will do it from the PPT. Whatever suits you, we will go ahead with that manner.
From Barrett, it will be convenient for us.
From Bare Act. So contract of indemnity and contract of guarantee, have you gone through that, Anusia? Like if you have any kind of no question that we have not completed in from the PPT, like or rest of our previous classes, if any kind of questions you have, then at least we will complete it this today, and then we will move to an agency. Or you are not revising it, or any of you are not revising it from the Bare Act.
And ma'am, I want the if you can explain the explanation illustrations of continuing guarantee section 129.
I think there is some technical problem. Just cooperate. Okay, we are discussing about contract of agency. So, do you think consideration is required for creation of contract of agency?
No, ma'am.
No. Okay. And why so? Why without consideration? Because consideration is one of the essential element of contract. Uh, is there any kind of problem with my video or something? Hello? Am I audible? I think there is some problem with the. Am I audible to you, all of you?
Yes, ma'am.
Yes,
Okay.
ma'am.
Okay. So we are discussing why the for agency consideration is not required. Why without consideration there is agency? कोई तो रीजन होगा ना, लॉ ऐसा
Ma'am,
allow
here
करने के लिए.
agent work on behalf of the president, principal.
Hmm.
Formal
Correct.
consideration is not there. So,
So basically, SRD, you are trying to say that agent and principal are same. So there is no requirement of consideration. This is what you are trying to say. Formal consideration is not there, right?
yes, ma'am.
Like if you are assigning some work to your nephew, and a nephew is doing something on your behalf, is he is doing, or whether he is doing or you doing, it is same. This is what you are trying to say. Because of that reason, consideration is not there.
Yes, ma'am.
Anybody else? और क्या रीजन हो सकता है? This is the correct reason, that principal and your agent is both are same, and there is a vicarious liability between, no, whatever the agent is doing, for that principal is liable. And in our real life, if you see that agency is created either through express authority or through implied authority, right? So suppose if you are giving certain tasks to your nephew, and he is doing some work on behalf of you, and he has done something which is, yes, if he has done something which is through which some kind of loss happened, and to a third person. Suppose if you have given something, some packet to your nephew to deliver it, and it has some leakage. Because of that leakage, the third person who has received that item, uh, he incurred some loss because of that. So now, whether he can sue you or not.
Yes, ma'am. He can sue.
Yes, but you might but you might say that ki, okay, this is delivered by your nephew, and I have not delivered to you. So this loss is occurred because of his negligence, or because of his any of the reason you can mention. And you can say that there is no contract, right? Because the essential element is not there. That is one consideration. So if the consideration is not there, so because of his act you will not be responsible. This might you will put it up in front of that third person, right? But in order to avoid this scenario only, the consideration component is not provided by the intent of the law is no, removing the consideration component is this. And now, even if there is no consideration between you and the your nephew, there exists a agency, and because of this agency you will be liable for all the loss which he has done on your behalf. I hope this is clear. So, implied authority intact. This is an implied authority which you are provided to the nephew. So, practical problem of enforcement to be taken care of by this. If there is no consideration, and then you are taking no recourse that okay, there is no consideration, so there is no contract between you and your nephew. So this you cannot no through this the third party is not going to sue you. That will not happen. And this is one another example. Mr. A, being a goldsmith, asked his son to deliver gold ring at his girlfriend Rosie place. However, he delivered to his mother. Now if his girlfriend wants to sue Mr. A for non delivery, then whether he can take defense that there is no agency between he and his son, as there is no consideration. He cannot do that, right? Because there is an implied authority given by him to his son, and there is an agency. Third point is acceptance of office of agency is regarded as a sufficient consideration for the appointment. So his son is taking the his son is willing to do that work on behalf of his father, so he has accepted the office of agency, and that is enough consideration here. Many of time you have seen that lawyers are uh, working in the no, senior lawyer officer, so there also they are not receiving any kind of remuneration, but they are working on behalf of them, so there is a agency here in that case as well. Power of attorney is one of the example. Then if you are asking your nephew to bring 1 kg of rice from shop, or if you are asking to anybody in your house to do some, no, like switch on the fan or anything, if you are asking for, at that time, that person, whatever you have asked him to do on behalf of you, that person is acting as an agent of you. So in case of agency, do you think how many parties should be there? It should be principal, agent, third party, or can a principal and agent, only two-person can be also there in the agency, I mean in the transaction of agency? Like can the agent be a third person himself? In this example which I have mentioned in the PPT, principal appointing Mr. A to sell his land to A, is that possible?
No, ma'am.
So here the agent is A, and he's selling land to himself. So when he's selling land to himself, then Mr. A is a third person. Why it cannot be possible? Through a power of attorney, you have seen movies also wherein a person is selling to himself. I think there is one movie, if anybody can tell me the name of the movie.
But ma'am, here A is acting on behalf of the principal. So how he can sell the land to himself?
So A, when A is appointed as an agent, but he can sell his. Suppose Mr. Principal is saying that I want to sell my land uh, uh, at rupees 1 lakh. Anybody who is interested to buy that, he can no pay me 1 lakh, and I will sell my land. Now A himself can pay that 1 lakh to principal, and when he's and can buy that land. That is also a possible situation wherein the agent can be a third party. This is what I was trying to know, give you an example out of that. So when we will read the barrack, you will find that essence out of the understanding that the person who suppose in one of the movies also it happened. I think I'm not able to recall the name of the movie. It is a very no, popular movie. So in that, the person is having the power of attorney, and he himself sold that entire property of the principal to himself. That is a completely valid transaction here. So when he's selling land to himself, that time he is third party, and when at the time of buying he's a third party, but when he's selling through a power of attorney, that time he's acting as an agent. So both the head he can wear it. Okay. Now, to whom sub agent is responsible? Okay. So this there is three terminology which we have discussed. We have mentioned in our PPT. One is your principal, second is your agent, and third is your sub agent, right? So agent appointing any other person to do the task of his, then it is sub agent. That that means that third person is not appointed by the principal. Agent is appointing a person to do his task, then it is a sub agent. That sub agent is should not be appointed by the principal. If the third person is appointed by a principal, then it becomes agent only. Okay. So agent appointing a person, then he or she becomes sub agent. So you booked travel from XYZ trip, and the in this case, uh, you being the third person is taking a service from XYZ trip company. Okay. and this XYZ trip company no provided a cab. Means he also this company also taken some service of the cab, travel agency who is providing the cab. So that cab doesn't show up on the date when you have mentioned to show up. Okay, then whom you will sue? We have already read about doctrine of privity in the contract, right? So you need to apply all this concept here. There is a third person, which is you, and principal is XYZ trip because you are taking service from XYZ trip company, right? And th- again, XYZ trip is sending a cab, and the cab is not showing up. So between whom the contract happened? SRD, will you able to say that?
Ma'am, the contract has been happened between the me and XYZ trip.
Yes. So if cab will not show up, then in that case you will show only XYZ trip, not to the cab person, right? And if
Yes,
you
ma'am.
if you don't show up, then whom the cab person asks for compensation? So here the cab person has an contract with the XYZ trip. So the privity of contract is between XYZ trip and the cab. So cab will ask for the compensation for from the XYZ trip, correct? So
Yes, ma'am.
if I will no, complicate it further, if you book travel from Make My Trip and Make My Trip call the travel agency to look into this. So Make My Trip is your principal, and Make My Trip is calling the travel agency. The travel agency is an agent of Make My Trip, correct? To look into this, and then travel agency send the cab. So who is the sub agent here? Travel agency is your agent.
Ma'am, the cab is sub-agent here.
Yes, yes, the cab is the sub agent here. So if cab doesn't show up, then whom you will sue?
And I will show to make my trip.
Correct. Exactly, it is the same thing. Even if how many people will be no included in this entire transaction, the doctrine of privity will apply here, and then you have made the transaction between with you and the Make My Trip. So you will obviously sue Make My Trip for this any kind of default happened by no travel agency or by the cab driver, anything. So here in this entire question, if you will see that third person is you, sub agent is your cab driver, and the principal is Make My Trip, and the agent of Make My Trip is your travel agency, correct? The principal liable to whom? To you, obviously, because you has right to sue principal. So if anything happen, any kind of loss or any kind of transaction, any kind of misrepresentation, fraud, or any kind of loss, or any kind of no insufficient service happen, then in that case you have authority to sue, you have right to sue principal. So principal is liable to third party only, that is you. Sub agent is responsible to whom?
Agent.
Right. Sub-agent is responsible to agent because agent is the appointing authority here. Sub-agent is not appointed by the principal. So if anything which the sub-agent will do, who will be responsible to principal?
Agent will
Agent.
responsible.
Yes, yes. I hope this is the mostly no tricky thing in the agency. Otherwise, everything is very smooth. So if you have this clarity, no principal, agent, sub agent, and the relation between all this, and who will be responsible to whom, and the privity of contract and the consideration thing, then the rest of the sections are very smooth to you.
Ma'am, in this case, who is the third person?
Who is the third person? You have taken the service, na,
Yes,
from the, yes. So you can, if instead of this you can put any kind of scenarios, like make my trip is providing service to Mr. A, and make my trip has no taken uh, has this travel agency as agent. So here, that in that case, Mr. A will be the third party, right? Whomever you are providing service will be the third party, because these people all are working on behalf of make my trip, right? So, what is the test of agency? Whether the person has the capacity to bind the principal and make him answerable to the third party. When in any of the cases, any of the example or any of the cases which comes to you in your exam, and or in your real life scenario, you have to see whether this person has capacity to bind the principal and make him answerable to the third party. If yes, then only there is an agency. Otherwise, no. Because what is happening, principal and agent is what, like principal and agent are both the same, right? Agent is representing principal. What the principal has, if suppose, if in your case, suppose if you would have done something by yourself, and instead of you doing it by yourself, you have asked your nephew to do it. That means your nephew is representing you. This is how the agency is formed. And that's what, whatever the action as your nephew is going to do, for that you will be responsible to the third party, correct? So what he is doing, he's binding you with, from whatever the action he is going to do, or he is going to take, for that he's binding you, right? So the person has the capacity to bind the principal and make him answerable to the third party is an agent. Second is whether he can establish privity of contract between the principal and the third party. So when you have sent your nephew to any grocery shop to buy something, right? So when he's buying 1 kg of rice, and he's saying that okay, it will be paid later on. So what the shopkeeper is thinking, he's selling to you, not to the nephew, right? So doctrine of privity is happening here between you and the shopkeeper. Shopkeeper has if nephew will not pay that amount, or like obviously he will pay on your behalf, or if you have not paid that amount to the shopkeeper, then shopkeeper has right to sue, not to the nephew but to you, right? So third party has right to sue to you only because there is a doctrine of privity operating here. I hope it is clear. So what exactly happened in agency? Relation between an agent and his principal, wherein principal authorize an agent to create contractual relation with third party. This is what we have seen in the earlier example which we have discussed. The contractual relationship is not happening, then in that case there is no agency. So qui facit per ellum, facit per se. If I am pronouncing it wrong, then please pardon. So he who acts through an agent is himself acting. This is the underlying concept of agency. uh, we have discussed about sub-agent. Person appointed by the original agent is a sub-agent. Original agent is responsible for his acts to the principal. Okay, substituted agent. What do you mean by substituted agent? Suppose if you have asked me to file an ITR, and I said that okay, I am busy, I think you can take this, there is also one XYZ firm, you can get it, your ITR to be filed from this firm. In this, what is happening, I am giving a reference to somebody else. right? And you are taking the service from that XYZ firm. In that case, am I a agent of you, or any kind of relation between me and you is there here when I'm just giving a reference of some other firm? I'm an agent. Okay. Anybody else? SRD is saying that I am an agent here. Anybody else has different opinion or understanding? I'm just giving in what is exactly, like if I give an just a reference that XYZ firm no can file your ITR. I am busy. I'm not able to do that. Am I representing you? What is the no uh, test of agency? We have just discussed. Am I binding you and the XYZ firm? Or suppose if you are no you have a car. Yes. So, or you can see in your real life also, like suppose you have a pen, and your friend asked for a pen, and you are saying, okay, I need this pen, and I think uh, 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 your other friend, like say Rosie is having two pen, you can ask her. So if you are asking Rosie, then there is a transaction between you and the Rosie, and not between you and me, right? Because you have not given any pen, or you have not having any kind of transaction between, you just given a reference. He might ask from Rosie, or he might ask from anybody else. So person named by an agent in his place, that will be called as a substituted agent and not sub agent, because test of agency is not there. Okay, so whatever we have discussed, that I have just noted it as a rule of sub agency. So first is your work under control and direction of agent. So the, the sub agent must work under the control and direction of agent. So when I but the substituted agent is not working under the control and direction of agent. If I have mentioned the name of XYZ firm is independently filing the ITR of on your behalf, and not under the control and direction of me, right? So here this XYZ firm is not sub agent of me, and neither I am an agent of you, because there is no agency has been formed between you and me. I just given a reference, right? But if suppose you have given me the work, no, no, you only have to file. If you are not filing, then you can get it filed from anybody. I will be only asking you, like I will be responsible to you. Then in that case, there is I will be acting as an agent, right? And if I am getting this done through my employee or anybody else, then there is a sub agency created. Second is your agent delegates a part of his own duties to sub agent. That's what uh, sub agency and the agent and the sub agent relationship is. If there is no task to be assigned to sub agent, then there is no, obviously there is no requirement of sub agency, right? No privity of contract between principal and sub agent. So in that example which we have discussed, the make my trip and the cab driver and travel agency. So the cab driver is your sub agent. So there is no the travel agency is doing is appointing the cab driver. So there is no contract between the principal and the cab driver. So no doctrine of no privity of contract between the principal and sub agent. Sub agent is responsible to the agent only. So if the cab driver is not showing up at the no, location, that time the travel agency has right to sue cab driver, and not the principal or the third party. Agent is responsible to the principal for the acts of the sub agent. Okay, so this is obviously clear, we have already discussed. But one more important thing, uh, if sub agent is not performing the duty, what he has to show up, right, on the location, if he's not performing that duty, then third party has right to sue principal, right? So if that is not happening, if the sub agent is not appointed under the legal authority provided by the agent, by the principal to the agent, suppose in the agency agreement principal has already mentioned that it has to be performed by you and not by anybody else. In that case, if the agent is appointing sub agent, and then sub agent is not performing any work to the third party, then what will happen? You have to think about it. Okay, now, subagent has no right of action against the principal for remuneration due to him. This is also very clear. I hope the question which I have asked is clear, or you have. I have to repeat this question. My question is, if there is no authority given to agent to appoint any other person as sub-agent, in that case, if the sub-agent has been appointed by the agent, and agent sub-agent has not performed the activity, then in that case, the third party will be responsible, will have the right to sue principal or not.
No, ma'am. Then agent personally liable to the third party.
Okay, I'll give you as a task. Okay, note it down and give me the answer tomorrow with reasoning. I need the reasoning, the section number, what exactly the section is saying, and how this authority. Because any of the answer when you say no, that has to be, while writing the answer, we have to mention what the law says, and how you are applying that law, and then your understanding, like your application, and then you have to mention the conclusion. This is how the answer flow.
Ma'am, can you repeat the question again?
So if I am saying that principal has mentioned that this work has to be performed by you, and there is no right is given to you for appointing any subagent, and in that case you have, instead of you doing the performing that function, you have appointed subagent, and that subagent has done some mistake or has not done that work, whatever be the case, right? In that case, whom the third person will sue, and in this entire scenario, who is responsible to whom? Everything you have to mention me in the
Ma'am,
answer.
agent is responsible before the principal.
Agent is responsible to the third party.
Yes, ma'am.
Okay, we have initially just we have discussed that test of agency. Okay, what we have discussed, whether the person has the capacity to bind the principal and make him answerable to the third party. So third party is doing transaction with whom? In this we have discussed now, who is the third party here? uh, do you is able to see any privity of contract here, right? This all this question you have to ask in any of the scenarios when you are framing the answer. If the privity of contract is there, then between whom the contract is there, then you have to find who is the third party, who is the principal, who is the agent and the sub agent. And then all these questions, when you are just forming all this question na, then you will get the answer, and this is the test of agency. The third party principal should be answerable to the third party. If there is an agency, then in that case principal will be answerable to the third party. If there is no agency, then principal is not answerable to the third party, right? So agency is there, right? You agent has done mistake, but agency is there. A valid agency is there or not?
Yes, ma'am.
So now you think the valid agency is there, then the third party is not bothered, no? Who like, it has to be performed by the agent. So in case if any of the mistakes agent do, then agent will be responsible, but third party will sue to him.
So, ma'am, third party will sue to principal only.
Exactly, this was the question.
Ma'am, if any default is happening on the part of agent, that third party will only sue to principal, not to the agent or sub agent.
Sub-agent is not, there is no contract happened between, no, here you have to see that
Yes,
who
ma'am. Yes, ma'am.
who sue whom, that you have to see. And third party can sue agent also, but in that case uh, all the expenses, all everything has to be recovered by the agent will recover it from the principal. So it is like principal and agent are same in that case, no? Obviously they are same, then there is an agency. So but agency, through agency what is happening, that principal is answerable to the third party.
Yes, ma'am. Got it.
Hmm. Rule of substituted agent works under the instruction of the principal. When I'm saying that, okay, have given a reference of xyz firm, wherein you can get your ITR file, then you that xyz firm is working under your instruction and not under me. So works under the instruction of principal. Agent does not delegate any part of his task to the substituted agent. I have no relation with that xyz firm. I will not delegate my task to him. Okay, but in case of agency and sub agency, what is happening? I am delegating my task to the sub agent. Privity of contract exists between a principal and the substituted agent. So now I just given a reference. So there is no transaction between you and me, neither between you and the XYZ firm. There is the contract. The contract happened between you and the substituted agent. Okay. So there is a doctrine of no the privity of contract is between you and the XYZ firm. I am not the party in this transaction. Responsible to the principal. Substituted agent will be responsible to the principal and not to me or anybody else. Okay. Agent is not responsible to the principal for the acts of the substituted agent. So you came to me to file an ITR. So if I have given just a reference that okay, this person will be substituted agent, like he will be performing task, then in that case, I will not be responsible in any of this act or any of the transaction happening between you and the substituted agent. Substituted agent can sue the principal for remuneration due to him. This is obvious. Okay, so what if principal died before the completion of task given to agent? What do you think?
Ma'am, if principal died, if that work has been delegated to any other, that charge has been delegated to any other person, then he will be responsible.
So agency is between principal and agent. When the principal is no more, then there is no agency remains. It's terminated. Yes, XRD, correct. So in order, there is if suppose uh, agent is aware about the death of the no uh, about the death of the principal, in that case what will happen? And if he is not aware about the death of the principal, then what will happen? So there will be two scenario. So again, when the when principal died and the task has not been completed yet, then in that case what are the options remain with the agent? One is your first of all, it will be agency will be terminated, that is obviously, because when principal is not there, then how the agency will be there, right? So in that case the agent will not perform that task, or if he will perform the task, then it has to be ratified by the legal hire of the principal. If the legal hire yes, if the legal hire is not no ratifying the sorry, my daughter. So if the legal hire is not no ratifying that transaction, that means whatever the acts and uh, liabilities incurred by the agent will be responsible by himself, and it cannot be recovered from anybody else. But if the legal hire is no ratifying that transaction, then only he can recover that amount from the legal hire. I hope it is clear. Okay, so who can be an agent? Any person can be an agent, including minor or unsound mind, person of unsound mind. Okay. So but we have studied in our no at the time of understanding the essential element of contract, that there is no contract between minor, and there is no contract between with the yes, SRD, correct. So there is no contract with the your person of unsound mind, right? So how the agency is created? Because contract of agency is also one contract.
Ma'am, he or she will act in the direction and control of the principal. That's why.
Yes. So then that means that principle must be measure and sound mind. Okay.
Yes, ma'am.
In then only it is possible, because agent is just representing principal, so principal will be liable. So agent may be your minor or the person of unsound mind, or both, right? But in this case, what is happening, since between principal and the agent, since the agent is a person of unsound mind or a minor, so between agent and the principal there is no contract, valid contract. But there is an agency. So if the agent is doing any kind of act because of which any loss incurred, because of any negligence of agent, if any loss incurred to principal, then principal is not able to recover that loss from that minor person who is acting as an agent on his behalf, because the transaction between the minor and the principal is void of an issue. I hope it is clear. See, rule of caution says minor or unsound mind should not be appointed as an agent because he is an incompetent to contract. And in case of his misconduct or negligence, the principal shall not be able to proceed against him. Why? Because he cannot enter into a contract. He can act as a agent because he is representing principal, who is major and sound person. So if I give you an example, you send your 17 years old nephew to sell diamond ring for 1 crore, and he sold it for 1 lakh. He couldn't understand difference between crore and lakh. Say, okay, since your nephew is minor and a contract with minor is void of an issue, so no right against your nephew. So no right, you don't have any right against your nephew for claiming the compensation for having not obeyed your instruction. Is it clear? आपको समझ आया या कोई डाउट है?
Yes, ma'am. समझ गए.
है ना? ठीक है. So who can appoint? So principal should be always major and sound person of sound mind. Okay. Modes of creation. It can be either created in expressed manner or implied, or estoppel or holding out, by necessity, by operation of law, and by ratification. Now express is very much clear that either you are going through any kind of written agreement, like power of attorney. When we are doing registered power of attorney, that is an expressed mode. Like implied, when you are just saying to your nephew to do certain task, or anybody else to do certain task, then that's what is happening, it is an implied one. agency is created. Estoppel. So what do you mean by estoppel?
And estoppel means to stop someone. If he allow, firstly he allow something, then he cannot deny.
Mm-hmm. So who is allowing whom here in case of when the agency is created? Who is actually allowing whom? Like the agent is doing or the principal?
And principle.
Yes, correct. So if I can say that if you are sending your nephew to buy certain stuff from a grocery shop, and like say he's for continuous 6 months, okay, in that case, and you are every time whatever he is buying from that grocery shop, you are paying that amount to the shop owner. In this case, what is happening? You are stopping yourself as a principal, right? And your nephew is acting as an agent. So on seventh month, if he buys something and you are saying no, I will not pay, in that case the shopkeeper has right to recover that amount from you or not? From first, yes, SRD he has right to recover. But if you see that from first day to no, entire 6 months duration, you never have no done any kind of conversation from the shopkeeper, or you have not given any instruction, okay, what to be sold to him, or any kind of list or any nothing, no communication happened between you and the shopkeeper. Every time the nephew went there and bought some stuff, and after a month and or 2 months and you just pay that amount to him. Okay, there is no communication between you and the shopkeeper. But when you are paying that amount, then you are stopping yourself, and you are acting, then you are making a representation in front of third party that you are a principal and nephew is your agent. So on seventh month also, if some liability nephew is incurring, in that case you have to make the payment. That's what it is saying. So let's no read that. What do you mean by estoppel? Principal must have made representation. uh, so that in the example which I have given, it was an implied representation, right? It is through a conduct. So he may represent himself as through express manner also. Representation may be expressed or implied. Representation must state that the agent has an authority to do certain act, although really he has no authority. Okay, so if suppose you and the family of the nephew, you have no cordial relationship. So even if so it is normal that that nephew might should not be your no acting on your behalf. But in that case also, through conduct, you have made it certain that he is representing on your behalf. Third person induced by such representation. So obviously, since you are making the payment, third person was induced and always no giving certain stuff whatever the nephew has asked on no like it has to be paid later on in time, believed such representation and enter into a contract. Okay, so the next point is your ratification. So what do you mean by ratification? We have discussed many a time.
Ma'am, it is the authority to do a work without the permission of the such person.
Ratification happened before or after?
Ma'am, after.
So there is no obviously authority given. So some task is already performed and then you are ratifying it, right?
Yes, that's why it is called that it is an authority to do a work on behalf of other. Later he rectify it or deny it.
Yes. So there. Okay. So where acts are done by one person on behalf of another, but without his knowledge or authority. So there is no authority in first place. But that person has, so in any person's on behalf of any person, if you are performing any task for which you don't have an authority, that person has right whether to ratify it or not, whether to accept that transaction as valid or not, right? So he may elect to ratify or to disown such acts. If he ratifies them, the same effects will follow as if they had been performed by his authority. But if he doesn't, then in that case, you will be responsible for all the transaction which you have done it without authority. Okay. Ratification may be expressed or may be implied. That the thing which I have said, that suppose the nephew is doing something which without his authority. If I say there is no representation without his authority, if he's doing, and later on he make the transaction good, then in that case you are ratifying that. So ratification may be expressed or may be implied in the conduct of the person on whose behalf the acts are done. So the essentials of valid ratification is express or implied. So if I give you an example, your nephew without your authority gave your car on rental. Afterwards, you accept the rental amount. In this, what is happening? You are ratifying that transaction, right? Through a conduct. So second is your whole transaction must be ratified. So you cannot choose that okay, half of the transaction I will ratify and half of the transaction I will not. So if I give you an example, your nephew went to participate racing competition, okay, and incur 1 lakh as an expenditure and won the prize money of 10 lakh. So you can't keep 10 lakh entirely and don't pay for expenditure. You cannot say that okay, half of the transaction I am ratifying, I'm happy with the no 10 lakh amount as a prize money, I will receive it, but I will not incur that expenditure which you have incurred for participating in the racing competition. Okay. So you have to accept the entire transaction, you have to ratify the whole transaction. Third is ratification not put third party to damages. So what exactly it means? कि you when you are ratifying any transaction, it should not be no injuring third party. The third party should not be incurring any damages, or any kind of injuries should not be happening to the third party. So if I give you example, you gave a car to your neighbor for certain work of her, and then your nephew before the completion of her task ask for its return. So if you ratify this, then it's injured the third person, right? Because you have given your car for certain work, and that certain work has not been completed. Then in that case, it will be no it will be an injury to that third person. It has damages to the third person. She has or he has taken it for certain purpose, and this demand cannot be ratified by you so as to make your neighbor liable for damages for her refusal to deliver. So if you suppose, if since the third person if your nephew is asking the car back from the neighbor, that means he is acting on your behalf. If it will amount it like that, in that case, what if the neighbor is not returning back the car, then you have the authority to sue him or her. That will again bring her to be into a position of sorry, just give me just a minute. I'll just answer my daughter and then I'll come back. Okay. So is this example is you're able to understand, or you have any kind of confusion in this? So if suppose the third person has no is not in the position of any kind of injury happening or damages happening, then in that case that is fine. You can do that transaction, you can ratify that transaction. But if it put into any kind of damages or any kind of injury to that third person, or any kind of loss happened to the third person, then in that case you cannot ratify any the transaction, the act which your nephew is doing or an agent is doing. Okay. This ratification should happen within a reasonable time. It can't happen no in indefinite period, or any the period should be reasonable. uh, Communication, obviously it has to be communicated. and acts to be rectified must be valid. So what do you mean by valid? Valid, when we are seeing that the essential element of the contract should be there in it. The transaction which you are ratifying, it should meet the essential element of the contract. So you can't ratify your nephew action of forging your signature. Yes, SRD, correct. You suppose your nephew has forged your signature and sold all of your property to some third person, or to in that case you cannot ratify this transaction because the essential element is missing. Or if your nephew has killed somebody on then in that case you cannot no ratify that transaction again, or hit somebody's car or anything which is not permitted by law. So any of the essential element is missing, then that kind of transaction can't be ratified. Okay, full knowledge of facts, this we have missed. So you thought he gave Alto for rupees 1k per day basis, but he gave BMW. So whenever you are ratifying any transaction, you should have the incomplete fact knowledge of the facts. Nothing should be missing in that communication. Your agent should inform all the elements of the transaction, then only the ratification possible. Okay. Principal is not always bound by the acts of the subagent. This question you have to answer me. You have to write it down and give me. Please take note down this question. Principal is not always bound by act of a subagent. You have to write it down, Sadi, and send me over email. Okay. I'll just drop you the. I'll drop my email ID in the chat box at the end of the class. Duties of agent: to act according to the principle. I think in please go through all the points. Do you have any kind of any point you have any no question, then we will discuss those point only. This is very self explanatory. Like, to act according to principle, you have to take a reasonable care, present proper accounts. Like, you cannot fraud in between any kind of transaction. If you have given 100 rupees to buy something, then you have to, if it is 80 rupees cost, then 20 rupees you have to return. You have to just provide all the proper accounts to the principal. Communicate with the principal. So suppose if in case you have any kind of difficulty in the transaction which has in any work which has been provided to you to do, and if you are having any kind of difficulty, then you have to communicate to that thing to the principal, not to deal on his accounts. So if I will place Mr. A as an agent, okay, to sell something, say AC, and there is some parts which is having some problem, then in that case Mr. A will not say to the third part to the customer that okay, you don't inform to the head office or to me about this, and I will get it repaired by myself from my own no servicing shop. Okay. So you should not be dealing on his own accounts. The agent should not be dealing on his own accounts, not to make secret profit. So if suppose if in this transaction, suppose the I have asked him to sell at 1 lakh, and he's selling at 1 lakh 50,000, so he's making any kind of secret profit from this transaction, right? So he shouldn't be doing that. And not to delegate authority. So suppose if I have mentioned that you should not be appointing any sub agent, then he cannot delegate his authority or his duty to perform that work. Pay sums received. So whatever the amount he is receiving on my behalf, he has to no pay me. Not to misuse information obtained. So any kind of confidential information I have given it to the agent, he should not be misusing that information. Like suppose if I am saying okay, it is 80,000 in after no in another city, the same AC is getting sold at 50,000. So I will not be, you being an agent, you will not be informing to the customer this information and making some kind of profit out of this information. Okay. So not to misuse information obtained. Rights of agent. So what are the rights of retainer? So it means that whatever the money is due to suppose the agent if I have no appointed an agent for a certain consideration, so whatever the amount I have agreed to pay as a remuneration, that from this itself, this sale of AC, if I say he has recovered, lien is different thing. Lien is different thing. Okay. So it is about right of retainership. So about from the money, retainer lien is on from on movable and the immovable property. So this we will discuss in the next topic. So right of retainership is like if the agent has received certain money from the customer. Suppose in this example, by selling an AC, he has received 1 lakh rupees, and he has and and suppose he is receiving 20,000 as a remuneration from me, and he has incurred certain expenses while selling the AC to the customer, say 5,000. So he is recovering how much? 25,000 from me. He has sold AC uh, at 1 lakh rupees. So he has received 1 lakh. So he can deduct 25,000 and return me the rest of the amount. So right of retainership, all money due to himself, any expenses incurred, such remuneration. Such right can be exercised on any sums received on account of the principal in the business of agency. Okay. So to receive as agreed, okay, right of lien, to receive as agreed. What do you mean by that? Ki if I have said that ki 20,000 will be a remuneration, then he has right to receive that amount. He cannot later on say that, no, no, I will receive 30,000 from you as a remuneration. So what has been agreed, he has right to receive that amount. Right of lien, only on property belonging to the principal and received as his capacity of being agent during the course of his ordinary duty, and not in suppose he has whatever in the ordinary transaction between if I have appointed that person for selling AC. Okay. But I do also have say grocery shop, and one customer has returned 1 kg of rice to that agent. So in this case, for recovering his amount, he cannot no, put right of lien over that 1 kg rice. He has only having right over any kind of any of the property which is there in the AC uh, in the AC shop, and not in any of the transaction happening in the grocery shop. I hope it is clear. And this should be okay, uh, and only on the property belong to the principal. So that, suppose if customer has suppose if um, uh, my friend has brought certain AC of his house, which is not the principal property, and asked you to keep it in the showroom. In that case, you cannot exercise lien over that AC. You can only exercise lien over the property of the principal and not anybody else. Okay. When right to lien lost, so if suppose if you through fire or any kind of thing happen, or somebody has stolen the entire property, so if the property has been lost, so you also lose the right of lien over that property. If you are waiving your right of lien, then also you are losing the right of lien over it, right? Because you yourself is waiving your right. Agent's lien is subject to a contract to the contrary. So if certain contract happened between me and the agent, say in this transaction, that okay, you cannot have this right, then that will be having hold over it. Okay. Right of indemnification for lawful act. What do you mean by indemnification? Indemnification we have discussed yesterday. Yes. So loss if by the conduct of the promisor or any third person, right? So in this case, to compensate for the loss, correct, Ananya? So right of indemnification for lawful acts. It should not be unlawful acts. So in this case, suppose if you send a gold ring instead of a diamond ring via your nephew. So nephew is your agent. So the recipient sue your nephew. Here your nephew has a right of indemnification against you. So I think somebody has asked me, the third person can only sue principal, or he or she can sue the agent also. So he or she can sue the agent also, right? But whatever the loss or whatever the expenses or anything happening to the agent because of this transaction, he can get it indemnified from the indemnifier, that is principal, because he is representing principal. Okay. However, agent doing any act in violation of penal laws, right of indemnification against acts done in good faith. So suppose if you have sent your nephew to deliver the gold ring to third person, and that gold ring you have no you got it from a thief. You are aware about that it is a stolen property. In that case, your nephew is acting in good faith. So whatever, if the third person is suing your nephew, then nephew is still able to indemnify himself or herself through you. Okay, because he is acting in good faith. However, agent doing any act in violation of penal laws, then no indemnification. So suppose if he has to deliver the pizza and he has jumped red light, then in that case, whatever the challan payment he has made, he is not able to no, recover it from you. Right of compensation for injuries. If principal neglects or injury due to his wants of skill, due to which agent was exposed to unreasonable risk. So if I say that being you as a scientist, you need to have certain skill, wherein you have mentioned that okay, this land place this land has no certain minerals which are very expensive, and you have not done your you have no you because of your no some problem in your skill or some kind of negligence from your side, uh, there is something which uh, is harmful. There is something, some gas is there in that land area, and when your agent dig that land, because of that release of gas, he has got some kind of disease. In this case, the agent can recover all the amount for the medical treatment because of your negligence or because of your no wants of skill which you don't have. So this is the last topic. Agency is terminated by revocation of authority. If you are revoking yourself from the agency, agent renouncing the business of agency, agent himself is saying that okay, I am not anymore be an agent, and on the completion of the task for which he was an agent, principal or agent dying or becoming an unsound person, principal insolvency. If the principal himself become insolvent, then in that case also the agency is terminated on expiry of time. So certain time duration if is there, then in that case, if that time duration has been expired, then the agency is also getting terminated. Okay, this is the question. uh, so I have given two questions to you to write. One is your sub-agency, the earlier question which I have mentioned, difference between the agency, sub-agency and the substituted agent. Okay, let's have a quick. Okay, is it possible for you to go through the bare act and then we will take a questions from there in our next class? Because what I have done, I have no bucketed all the understanding and under uh, like if you will go through the barrack, in every section is saying something, but what I am doing, I have just bucketed all the understanding in the, suppose many of the section is saying certain duties, so I have kept all the understanding under the heading duties, right? So similarly the ratification I have mentioned like that. So if you will go through the sections, you will get the same understanding what we have discussed. So are you going through that barrack or not, or should we again have to make one classes wherein we have to no go through each sections and then see that the understanding is there or not? So I'll just quickly show you the bare act, and we'll have Okay, let's discuss this. We have already understand what is agent and the principal. An agent is a person employed to do any act for another or to represent another in dealings with third persons. The person for whom such act is done or who is so represented is called the principal, right? Who may employ agent, and any person who is of the age of majority according to the law to which he is subject and who is of sound mind may employ an agent. Let's discuss the heading. Who may be an agent? We have discussed. Consideration not necessary, we have discussed. Agent's authority may be expressed or implied. Definition of express and implied authority. Okay. Extent of agent's authority. So we have discussed that he can have only to has authority to do every lawful thing which is necessary in order to do such act. So an agent have having an authority to do an act. Suppose if I have given any kind of task, so in order to perform that task, whatever lawful thing he has to do, that only he can do, and he cannot do anything else, right? An agent having an authority to carry on with business has authority to do every lawful thing necessary for the purpose or usually done in the course of conducting such business, and you're not required to say every single step to perform that task. So anything which is lawfully to be required to be done, that for that activities agent has authority. Okay. Agent's authority in an emergency. So in case, suppose if okay, this is one again. So in case uh, suppose if you have appointed a caretaker to look after the property, okay, and you just appointed a caretaker to look after the property, and some fire happened in that place, in that property. So anything, this is an emergency situation, so any steps or any expenses incurred by the caretaker to save that property, so that is what uh, you have to pay that entire expenses to that agent, because he's working uh, under your authority, because he was appointed as a caretaker of that property, and anything he has done during the emergency situation, you have to no reimburse that amount. So an agent has authority in an emergency to do all such acts for the purpose of protecting his principal from loss as would have been done by a person of ordinary prudence in his own case under similar circumstances. I hope it is clear. Okay. When agent cannot delegate, so this we have discussed about the subagency, right? Subagency we have already discussed. Representation of principal by subagent property appointed. Okay, this is again we have discussed. Agent's responsibility for subagent, this we have discussed. Subagent's responsibility, so the subagent is responsible for his acts to the agent but not to the principal, except in cases of fraud or willful wrong. Okay, this is the question which I have asked. Agent's responsibility for subagent appointed without authority. So if the subagent is appointed without authority, then in that case, agent will be responsible for all the acts. So responsible for the acts of the person so employed, nor is that person responsible to the principal. The principal is not represented, where an agent without having authority to do so has appointed a person to act as a subagent. The agent stands towards such person in the relation of principal to an agent and is responsible for his acts both to the principal and to the third person. The principal is not represented by or responsible for the acts of the person so employed, nor is that person responsible to the principal. Okay. If the sub-agent is making any transaction with the third person without the knowledge of the principal, in this case, it is we are discussing relation between principal and person duly appointed by agent to act in business of agency. So see, A directs B, his solicitor, to sell his estate by auction and to employ an auctioneer for the purpose. B names C, an auctioneer, to conduct the sale. C is not a sub-agent but A's agent for the conduct of the sale. This is this is the example which I have given for the reference of the firm. So similarly, it is a substituted agent here. He is not doing himself. He just given a reference of the other person. So shall we go ahead with the other the rest of the section, or you will read it by yourself? because we have reached to the timeline. Are you
Ma'am,
there?
we'll read it and get back to you after any doubts arise.
Yes, just apply those concepts which we have discussed. Yes, Ananya. Okay, so just apply those concepts and also go through each illustration. So you will not see the understanding is same. If you have seen this example, there it is not mentioned like substituted agent, but the understanding is same, right? So if you apply those understanding and then read it, it will be having no, the concept is be cleared. Okay, let's end the class. Any questions? Okay, then let's end the class. Bye. Good night. Thank you
Thank
all.
you, ma'am.
Good night. Yeah.